I'm having another meeting at around 5, so we'll start directly with the pension and retirement benefits. So I guess all the participants are of ICR system only, and they must be aware, and they are working in various capacities as LDC and UDC, uh, as in ICR system. So uh, when we talk about the pension and retirement benefits, let's think what it is. It is a social security for the employees of Government of India, which is extended to CCS pension rules. And when we talk about the pension and retirement benefits, the following is an exhaustive list which are covered under the pension and retirement benefits. The first one is the or family pension. Pension or family pension is recurring monthly payment, which is yeah, दे दीजिए, हो गया वो तो दे दीजिए।
सर
ठीक है,
आवाज नहीं आ रहा है।
देख लिया ना आपने? एक मिनट, प्लीज होल्ड फॉर मिनट, प्लीज वेट फॉर मिनट।
तो पार्टिसिपेंट, आपको अगर कुछ डाउट होगा बीच में आप सर से पूछ सकते हो।
जी जी बिल्कुल, हाँ। तो अगर हम लोग बात करें व्हाट आर द पेंशन एंड रिटायरमेंट बेनिफिट्स, तो दिस एन एग्जॉस्टिव लिस्ट which covers each and every aspect of the retirement benefits and pensionary benefits, which is say which accrues to a government employees who are covered under the old pension scheme. The first one is family pension or family pension. It is a recurring monthly payment which is generally half of the last basic, and accrues on the last day of a month to a pensioner or the family pensioner. Then apart from pension or family pension, a person can commit his part of the pension, which is at max he can commit 40% pension and get an upfront amount based on some factor, fitment factor, commutation factor, on which the amount is committed. Then apart from pension and CVP part, the gratuity is also payable to the retiree employees. Gratuities are basically of three types: service gratuity, retirement gratuity, and death gratuity. Service gratuity is payable when suppose a person say when a person resigns on technical resignation, he goes to some other state department or say some other central government, from autonomous body to central government, then service gratuity is payable. And other than service gratuity, in some cases when the service is less than 10 years, then also service gratuity is payable. Retirement gratuity is payable at the time of retirement, and death gratuity is payable to the family dependent of the pensioner, dependent of the employees. Then other than gratuity, leave encashment subject to a maximum of 300 days is also payable to the employee. Then the employees are given an option if they want to get settled at some other place instead of their place of duty, then the TA to travel that place along with all the benefits like which are payable in transfer TA is payable at the time of retirement also. Then the GPF accumulation, whatever amount is standing at a credit of the government employee is payable to him or her at the time of retirement along with the interest. Then in case suppose an employee dies in service, in that case deposit linked insurance is also payable to the dependent of the pension employee. Then there is a CGA, central government group insurance scheme. The maturity benefit of CGA LIS is also payable to the retiring person. So what are the three fundamental conditions for a government servant? GS stands for government servant. What are the three fundamental conditions for a government servant to be eligible for pension benefits? The first one is he must be confirmed in any post, that he should be a confirmed employee. He must have retired or deemed to be have retired. And he must have entered service prior to 2003. In some cases, wherein we all are aware that in some cases where the government employee has joined service after 2003, but the advertisement has been issued before December 2003. In that case also, the OPS is applicable, and the services rendered are taken as for the OPS benefit. So there are different types of pension. The first one is superannuation pension. Then there is a retiring pension. We will discuss all this in detail. Superannuation pension, retiring pension, voluntary retirement, invalid pension, compensation pension, compulsory retirement pension, and compassionate allowance. So coming to superannuation and retiring pension. So what is the basic difference between superannuation and retiring pension? Superannuation pension is payable when a government servant on attaining the age of 60 years, whereas retiring pension is granted on the following grounds. What are those grounds? Suppose someone has been retired compulsorily before his due date of superannuation, or suppose someone has been compulsorily retired under Rule 56 after attaining the age of 50, 55 years, or 30 years of service, or say under Article 459 of the Civil Service Regulations, or if suppose in case of if a government department has been a policy decision has been taken to close that department, and employees of that department are declared surplus. In that case, the retiring pension is payable to the employees of that department. Under what conditions a government servant employees becomes eligible for pension with less than 20 years of service? We all know that as on date, a minimum 20 years of service is required for pension for accruation of pensionary benefit. But in some cases, when the service rendered is more than 10 years but less than 20 years, then also pension is eligible in following cases. Suppose superannuation pension. Someone is joined on compassionate ground at the age of say 48. So when he will return, his service will be only of 12 years. So in that case, he will be eligible for the superannuation pension. In case of retiring pension, also, if suppose someone has been retired compulsorily or under FR 56J, so in that case also, if the service rendered is more than 10 years, but the total service is less than 20 years, then also the pension will be payable. Then there are certain other conditions also on absorption to a company, PSUs. Then also, uh, even if the services rendered are more than 10 years but less than 20 years, pension is payable. So if suppose after completion of how many years of suppose someone asks you after how many years of qualifying service by a government servant he may be required by the appointing authority to retire in public interest. So under FR Rule 56, if someone has completed 30 years of service, then assessment is placed, and if it is found that he is not deemed fit, he can be retired compulsorily also. Now coming over to ICR system, uh, these are certain conditions. We know the temporary status casual labor, whether the period rendered as by an employee as temporary status casual labor is reckoned as qualifying service. The answer is yes. 50% of the service rendered is 50% of the service rendered qualifies for the calculation of the retirement benefit. Someone has joined on probation, then he gets confirmed also whether the probation period is counted as qualifying service. Yes, it is counted. Training immediately before joining. Suppose some scientist joins as directly at NARM. In that case, whether the training period is counted as qualifying service, in this case also it is counted as qualifying service. Similarly, there are uh, things like uh, services rendered by an employee in a state government or autonomous body, whether it is counted as qualifying service. The answer is yes, it is counted, but it depends whether the leave salary and pension contribution has been received on behalf of that employee or not. In case if the leave salary and pension contribution are not received by the original department or the parent department, in that case that service rendered with those department is not counted towards qualifying service. So he will be taken as a fresh candidate. Now, In which cases, suppose someone goes on leave and whether these periods are counted as qualifying service. So CL, EL, any kind of leave is counted towards qualifying service. EOL taken on medical ground is also counted as qualifying service. Suppose someone has taken EOL without medical ground, but due to civil commutation, that then also it is counted as qualifying service. In ICL system, many of the scientific staff goes on higher studies or for technical studies by taking EOL, and that also is counted towards qualifying service. EOL, other than these options, whatever for we have discussed, does not count for qualifying service. Now coming to qualifying suspension, say period of suspension. If someone has been fully exonerated, then that is counted as qualifying service. Because once someone has been fully exonerated, no charge exists over that employees, and the services rendered is counted as qualifying service. If suspension is wholly unjustified, then also it is counted as qualifying service. If the proceeding ends with minor penalties, then also it is counted as qualifying service. In all other cases like major penalties, it is not counted as qualifying service. Now, skip these slides. Issues wherein some questions can be framed based on say the when we go through the previous year's papers for LDCE for this group, uh, uh, only those issues we will touch. Important instructions on mobility of government servant. So when a government servant who has been appointed before 31st December 2003 and was governed by old pension rules may continue in the same scheme. However, in these cases, their past service benefits must be transferred from their previous department to the new department. Okay. Suppose someone has joined after 2000, first, or someone has joined on or after 1st of January 2004, they will be governed under new pension scheme. But in case their advertisement has been issued before 31st December, in some cases, like we all have seen, some employees are covered under old pension also. A pension is required to be fixed, revised in the prescribed level in pay matrix and does not include any type of special pay like special pay, personal pay, etc. Okay. Suppose in ICL system earlier, people used to get some special pay, stagnation allowances, especially in case of technical staff. Uh, so in those are not counted towards pensionary benefit. Okay. Uh, Now this second point, this has been very recently reviewed, and someone who is retiring on 30th June or 31st December, the next increment accrues on the next working day, that is 1st of July or 1st of January. Now the Supreme Court has already allowed, and ICR has issued instruction also in this regard. ICR has um, endorsed the instructions of DOPT that in such cases the pension is fixed after calculating one increment on the old basic of the employee. So please ignore this not in this second point, since but in and this issue is applicable from 1st of January 2006. Those who has retired on 1st of January, after 1st of January 2006, and they have retired on say 30th June or 31st December, and their increment days falls on the next working day. So in that case, all such cases, pension has been refixed after giving one increment. However, up to 30th April 2023, only notional benefit has been allowed, and actual financial benefits accrues only from 1st of May 23. Pension is to be fixed in the level or pay matrix of the post held by the employee in the parent organization. and not by the borrowing department. Suppose someone in ICR system is assistant in one institute and goes on deputation as W in some other institute, and he's retired. He gets retired from there as W. So in that case, his pension will be calculated based on the actual position being held in the parent organization, that is being of the assistant. Now coming over to the family pension, so first we need to understand the definition of family for the purpose of family pension. So category one includes widow or widower up to the date of up to death or remarriage, whichever is earlier. So who is covered under the family pension for, or who is who all comes under the ambit of the family in case of for the family purpose of family pension? The widow or widower. In case of childless widow, the family pension may continue even after her remarriage. Son or daughter, including disabled children up to the age of 25 years, then disabled child. Children, including disabled child, will become eligible for family pension in order of their birth from eldest to the youngest. And mentally or physically disabled children will also get family pension for their life. So this is the say the list in which, and this is also the order in which the pension or family pension is payable. The first one is widow or the widower. In case of childless widow, the family pension may continue even after her remarriage. Then son or daughter, suppose the widow or widower is also not there. In that case, son or daughter, including the disabled child up to the age of 25 years. Then suppose the eldest child is he's all fine, but the or suppose the eldest child is a disabled child, then the disabled child will get the first pension up to the 25 years. Thereafter, the second child, suppose a daughter is there, the daughter will get pension up to 25 years or her marriage. And in case if the daughter crosses the age of 25 years, then the eldest child who is disabled will get the family pension.
So here I
Apart
have a
from that,
question.
apart from this, unmarried daughters also get pension for the life. Unmarried daughters above 25 years of age, widowed daughter or divorced daughter also gets pension for the life. Family pension shall be payable to a divorced daughter from the date of divorce if the divorce proceedings were filed in a competent court during the lifetime of the government servant or pensioner or his or her spouse. There might be a case, suppose some matrimonial dispute is there and the daughter of the government servant uh, goes to court and file a divorce proceeding. That divorce proceeding must be filed during the life of pensioner or family pensioner. Even if the decree is pronounced, actually the actual decree is pronounced at a later date when uh, pensioner or family pensioner is not there, they are not alive, then also the family pension is payable to the divorced daughter.
The doubt, sir.
Yes, yes.
Sir, in case of if anyone has twins and both are disabled dependents, in case of family pensioner, then how the pension?
Both are disabled and they are twins.
Yes, sir.
Venunaji, I haven't come across this particular case, and I need to go through the rules for this particular thing. But uh, in that case, but it will be better. I will check the rule and will get back to you in that case, because it's a kind of peculiar case, and prima facie, I don't think it is explicitly mentioned in the rule. Okay, so I will get back to you. Huh? Now, if suppose none of these categories are there, then are alive, then in that case, dependent parent can also get the pension. In case of dependent parent, pension is first payable to the mother, then the father. Again, after all these things, suppose parents are also not there, the employee didn't had spouse or any say children, then and in case if he is having a permanent disabled sibling, then also the pension is payable to the disabled sibling. Family pension is payable to the disabled sibling. Now, up to which period family pension is payable? In case of widow or widower, as I have already told, the pension is payable up to death or remarriage, whichever is earlier, except for the clause of the childless widow. Okay. That's what there is in second point. Family pension is payable to a childless widow after her remarriage if her income from all sources is less than the amount of minimum family pension. That is 9,000 right now, 9,000 plus dearness. If it is less than that family pension is to a lady, a woman who is childless widow and gets remarried. When a widow or widower becomes ineligible, then the children below the age of 25 years in the order of their say uh, age are eligible, or till they get married in case of daughter and son, or else if they start earning more than the minimum family pension. All three clauses are there. They should be less than 25 years. They should not should not have any earning of more than minimum family pension or the dearness. In case of uh, any children is suffering from any kind of disability, being physical or mentally disabled, in that case they are mm, the family pension is payable to them for the whole life. As I've already discussed that in all, if all these in absence of all the above say claimant, the family pension is payable to parent. In case of parent also, first to the mother, then the father. Last but the family pension is payable to permanent disabled sibling, subject to the condition that he should not have more than the mm, any earning more than the minimum family pension. Now, there is a concept of co-authorization of permanently disabled child in PPO for family pension. When a government servant has a permanent disabled child, his pension is co-authorized in the PPO itself. Okay. Uh, the pension disbursing authority shall authorize payment of family pension to a permanent disabled child whose name has been included in the PPO after receipt of the claim of on death or ineligibility of the family pensioner. So it's always, suppose in your office or in your surrounding, if anyone is there, a government employee is there who is due for retirement, and you know that any of his child is suffering from any kind of disability, you please inform them about this OM of 2020, March 2020, uh, just to avoid any kind of say inconvenience to them or their dependent at a later date. However, in case of a disabled child, uh, there is a certificate of guardianship which is issued by the local level committees under Section 14 of the National Trust Act, which is also accepted, uh, which is also required for the grant of the family pension. So, who is the competent authority for issue of disability certificate? Any hospital or institution specified for the purpose of by notification by the appropriate government, Section 2P of the Act. Uh, Family pension in case of missing employees. The family pension or retirement gratuity may be sanctioned by the department after observing the following formalities in case of the missing employees. What are the conditions? The family must lodge a report with the police station and obtain a report from police that the pensioner has not, the employee or pensioner has not been traced despite all efforts by them. The report may be FIR. It can be an FIR also. It can be a general diary entry or a daily diary entry. Then an indemnity bond should be taken from the nominees or dependent that all payments will be adjusted in case uh, the employee or pensioner appears and makes any claim at a later date. So, what are the common shortcomings which we observe in family pension cases? These are some of the common shortcomings, that family details are not properly entered in PPO, or in many cases, name and date of birth of the spouse or children are wrongly entered in service book, which leads to a, a huge inconvenience at a later date to the claimant. Then, family pension to dependent children, divorced children, or widowed children need to be cautiously sanctioned or authorized. Family pension to disabled child, this also need to be cautiously checked. Seeking change in the date of birth of 5, say retrogressing it 25th of June 1948 instead of 25 March 1950. Suppose someone has entered the date of birth as 25th March 1950, and at a later date they bring some certificate stating that they bring an Aadhaar that stating that date of birth has been wrongly entered. Because once you retrograde it, then the certain pensionary benefits like um, additional quantum increase gets due at an early date. Addition of wife, addition of a wife name at a later date, that also need to be checked properly. So now coming back to my first slide. I will go back to my first slide. So when we talk about the pension or family pension, so what is how it is calculated? I have already told. It is calculated at the half the rate of the last basic drawn. Okay. There are three some more calculations like last 10 months average salary or the last salary drawn, whichever is higher. So generally the last basic drawn is is always on a higher side. So the pension payable is generally it's half of the last basic drawn. Then CVP is calculated on a factor based on the age of the employee. It Right now it is 8.9 something in case of normal cases like those of administrative staff or technical staff. In case of scientific staff, it is 7.98 to something like that. And the formula is, suppose a pension has been fixed at rupees 10,000, so 40% of that is committed, can be committed. At max, it can be 40%. So someone applies for the commutation of 40%. So 40% of 10,000 is 4,000. 4,000 is can be committed. 4,000 into 12, say 4,000 into 12 is 48,000 into the factor. Factor, say suppose 8.194 or whatever it is, then whatever the figure amount comes, it's paid as CVP. This CVP is restored after 15 years of service. There might be some cases wherein the CVP, suppose in case of technical or scientific staff, or even in case of administrative staff, there is say upward revision in pension. Suppose a case, hypothetical case, we imagine that earlier when the person retired, you have fixed pension as 10,000, and at a later date, his pension has been refixed as at 12,000. Say for instance 12,000. So that additional 2,000 he can commute. He can commute. So 40% of that 2,000 is 800. So 800 can also be commuted at a later date. And this 800 will be restored. 800 will be restored after the 15 years of commutation of that 800 part. So there can be commutation can be restored in 2 or 3 different dates based on the commutation. Then the gratuity is calculated at the rate of 15 days salary for each completed year of service. Gratuity is calculated at the rate of 15 days salary for each completed year of service. And the maximum gratuity which is payable as of now is 25 lakhs. In case of death cases, it is 1 month salary for each completed year of service. Okay. In case of service and retirement benefit, it is 15 days of salary for each completed year of service. And in case of death, it is 1 month salary for each completed year of service. Now coming to encashment of leave. So whatever salary you are drawing for a month multiplied by 10, basic plus DA into 10. 1 month salary into 10, it becomes 300, or otherwise. Now, other thing, TTA depends on the eligibility or the class of the employee who is retiring. Now, coming back to the original slide. Madam,
छब्बीस पर ये कॉर्पस फंड का था ना, उसके अकॉर्डिंग भी मैडम कह रही थी कि मैंने कराया और ठीक है ठीक।
So now coming to the additional quantum, the one which is due from the age of 80 years. So at the age of someone crosses 80 years, 20% additional quantum is payable. After 85, it is 30%, 90, 40%, 95, 50%, and more than 100 is 100%. So if suppose the date of birth of a government servant is 31st July 1941, when he will in for additional pension of 20% as per government instruction. So whether he will be eligible from 1st of July or 1st of August. So the answer will be 1st of July 21, regardless of the fact that he is date of birth is 31st July and he will be actually be of more than 80 years on 1st of August 1941, but his additional quantum is payable from 1st of July 21 itself. That is the OM dated 2009 states that the additional quantum eligible from the date of the first day of the month in which date of birth falls. In which cases family pension is paid to more than one person at a time. Suppose in some personal laws allows more than one wife or wife. In that case, in case of more than one widow, family pension is payable to all the say widows. A widow and an eligible child to another marriage. Someone has is having a child with some other woman other than his wife, then in that case, after death of the government servant, the family pension is payable to his legally wedded wife and to the uh, uh, child of the child to another marriage. Or suppose someone has uh, uh, someone's spouse and he marries, and in that case also the child from the first marriage and the present widow will get both will get the family pension in an equal way. Is family pension payable to a spouse judicially separated? The family pension is payable to a spouse judicially separated, but not to the spouse judicially separated on the ground of the adultery. So in normal cases, family pension is also payable to a spouse who is judicially separated. Now, gratuity or death gratuity, coming to now the gratuity or death gratuity, a government servant who has completed 5 years of qualifying service becomes eligible for service gratuity. And what is the rate of calculation? It is calculated at the rate of half month's emoluments for every completed 6-month period of the qualifying service. A government servant who has completed 5 years of qualifying service on his retirement is eligible for retirement gratuity equals to 1/4 of his emoluments. So he will be getting retirement gratuity as well as the service gratuity. So, and Death gratuity is payable at the time of the death of the government employee. It is payable to the pensioners, say the family dependent or the family pensioner, and there are certain calculations based on the qualifying service. If suppose qualifying service is less than 1 year, the rate is 2 times of the emoluments. If it is less than 1 year but more than one, it is 6 times. For similarly, for more than 5, less than 11, it is 12, and maximum in case of 20 years, it is half of the emoluments for every completed 6 monthly period. I have told you half of monthly emoluments for every year. So if we calculate it, what is written in this slide? Half of the emoluments for every completed 6 monthly, or if we say month salary for each completed year of service. Both are the same, one or same thing, and subject to a maximum of 33 times of the emoluments or 25 lakh. Now, what is the definition for the family for the purpose of gratuity? For the purpose of gratuity, family means spouse, including judicially separated spouse, son, including stepson or adopted son, unmarried daughter, including stepdaughters or adopted daughter. So married daughters are not considered as a family for the purpose of gratuity. Then widowed daughter, including widowed stepdaughter or adopted daughter, father, including adoptive parent, if the personal law government servant allows it, mother, including adoptive parent, if the personal laws of government servant allows it, brothers or stepbrothers include who are less than 18 years of age, unmarried sisters, widowed sister, and divorced sister, including stepsisters, then married daughters, children of a predeceased son. So there are certain whenever some events take place in the life, whenever a government some certain event takes place in the family of the government servant, he must inform the office about the same, so that that same can be updated in the family records of the pensioner. What So, what happens to the validity of the nomination made by an unmarried government servant on acquiring a family subsequently? If the nomination is in the favor of any of the family members, then if an unmarried government servant makes a nomination in favor of any of the family member, as defined in the previous slide, shall not become invalid on his or her marriage unless the government servant cancels the previous nomination and files a fresh nomination. If the nomination is in favor of a person or an individual other than the family mentioned, then in case of, if the government servant does not have a family as defined in the previous slide, then he can make a nomination in favor of a person or body of the individual. The same will become invalid in the event of the servant subsequently acquiring a family. If suppose he didn't have any family and he makes a nomination in favor of certain person or a body of individual, and subsequently he acquires a family or he gets married, in that case the old nomination becomes invalid. So in case of ICS system, whether the retirement gratuity, death gratuity can be paid by pension authorizing unit, the answer will be no. The amount of retirement or death gratuity as determined by the pension authorizing unit shall be intimated to the head of office, who will draw and disburse the amount to the government servant or to the nominee as the case may be. So the pension gratuity and death gratuity is payable by the office from where the person retires, not from the pension authorizing unit. Can the payment of retirement of gratuity be made by the bank, directly by the bank? No. As on date, the in the PPO, the amount of gratuity and that gratuity is disclosed, and the same is payable by the employee from payable to the employee from where he retires. That is, suppose someone retires from IRI Delhi. Suppose someone retires from IIMR Hyderabad, and his or her pension authorizing unit is NRM Hyderabad. In that case, IIMR NRM will issue the PPO, and IIMR will make the payment of the retirement or death gratuity. Now, coming over to the computation of pension, a government servant is entitled to commute a lump sum up to 40%. It's up to the government servant to opt for a lesser amount, but generally people opt for a commutation of 40%. In certain cases, they do opt for a lesser amount also, lesser percent also. The date of effect of reduced pension after CVP is the date of receipt of the CVP or at the end of the 3 months after issue of authority of the by the PAU. With the CVP paid on a day after retirement or within the first month, the registration may be reckoned from the date of retirement. It need not be the case that the CVP should be paid on the next working day. If it is paid within 1 month from the date of the retirement, then also the restoration takes place after the 15 years and is reckoned from the date of retirement itself. The benefit of CVP cannot be given to the family in case employee dies within service. Suppose someone has died because he has not applied for commutation. Someone dies, then in that case CVP is not given to the family pensioner. There is no clause in CCS pension rule wherein a family pension can commute certain part of pension. The dearness is always payable on the original pension. It is suppose someone in our example, a pension of say, suppose we hypothetically example we took and we calculated pension as 10,000 and he has applied for commutation of 4,000. So the dearness will be payable on 10,000 and pension after commutation will be 6,000. 4,000 will be restored after the 15 years of service. Certain case study in CVP, if we take a pensioner dies before completion of 15 years from the date of retirement, will the portion of pension committed will be recovered from the balance period? No. In case of death of the pensioner before completion of 15 years, the committed portion is not recovered from the family pension. The family pension is payable at the rate of 30% and is payable in full. 30% of the original basic or 60% of the pension. DOB, date of birth of government servant is 1st June. He retires on superannuation on 31st May. That is a day before 60th birthday. What will be his commutation factor? The commutation factor is based on age next birthday. In this case, what will be the commutation factor? Commutation factor will be 8.194. 8.194. Okay, commutation of pension become obsolete on the date following the date of retirement. In the instant case, the commutation become obsolete on 1st June. Okay, even his date of birth was 1st June, since the person whose date of birth fall on the first day of the month get retires a day before, that is on the previous month, last day of the previous month. So in this case, his retirement will take place on 31st May and commutation becomes obsolete on 1st June. So his date of birth next birthday will be 61. He will be turning 61 on the next birthday next year, and accordingly his commutation factor will be 8.194. Now coming over to encashment of leave. So as I have already told that maximum of 300 days of leave encashment is allowed. A re-employed pensioner, someone has been re-employed and who has already availed 200 days of leave encashment, then the balance of 100 days is available to be, which is paid to him or her at the time of retirement. Income tax relaxation on encashment of leave. As on date, income taxes, we are not covered under this rule. The whole retirement benefits are non-taxable in case of ICR employees. Medical facilities to ICR pensioners. What are the medical facilities which an ICR pensioner get? Those who are under CGS facilities get benefits under the CGS. And in case of the cities which are not covered under the CGS facility or other than Delhi, ICR pensioner and his dependent family members were dispensary facility available in ICR institute in the place of their settlement, irrespective of the institute from where they retired. In case a pensioner wishes to settle at a place where either ICR institutes are not located or they don't have any dispensary, then the pensioner can get fixed medical allowance. Right now it is 1,000 rupees per month. Indoor treatment is fully reimbursed, subject to the limits of CSMA. Medical reimbursement in respect of indoor treatment in a government or recognized hospital by the institute concerned shall be admissible. In case of a pensioner, if he settles at a place where there is no ICR dispensary, then his case will be assessed as per the CSMA rule. The instruction permits reimbursement and no credit facilities available to ICR pensioner for indoor treatment. Some ICR specific additional instructions are there that this I will share with all of you. Say medical issues are a gray area for ICR because in many of the institute uh, we allow certain claims which are not otherwise eligible. So we need to be a bit cautious by allowing the medical benefits for the ICR. So in this basically for the pension authorizing unit, what are the checklist? Application form for assessing the pension and gratuity that submitted in triplicate, particulars of self, family, joint photograph in triplicate, duly attested by the head of office, service book, duly completed giving details of qualifying service, and the leave accounts duly updated. Service verification should be done by the head of office or officer authorized for the purpose. Statement of any say due or recovery to be taken place from the government servant, NDC no demand certificate, and nomination for gratuity. These all should accompany the pension case. Then 3 copies of specimen signatures duly attested by head of office, passport size photograph, vigilance clearance certificate, bank detail form. In case suppose someone was on a foreign service or he has served in some other department and then got absorbed in ICR, in that case LSPC, or say he has went on deputation, then also LSPC should be certificate of receipt of LSPC should be there. In case of invalid pension, medical certificate should be there. Okay. Then height and identification marks and application for the commutation. If he has applied for the commutation or commutation fees. Now, what are the documents which are required to be submitted for the family pension? Then application form, service book with the date of death, the specimen signature of the dependent, photographs, slips bearing left hand impression, finger impression, and uh, a descriptive role of the person along with height and personal identification marks, death certificate of the government servant, bank details, details of family so that the claimant can be identified from that family details. So some certain changes has been brought which were new after the 6 pay commission, that the pension will be 50% of the average emoluments or 50% of the emoluments drawn on the date of retirement. Gratuity has been enhanced to 10 lakh in 6 pay commission, which was earlier 3.5 lakh. Prior to that, from 6 lakh it became to 20 lakh, and right now it is 25 lakh. Enhanced family pension for 10 years. Earlier it was 7 years. Family pension to childless widow even after remarriage. Family pension to dependent disabled siblings of the central government, which was not there prior to 6 pay commission. Additional quantum of pension so as to cover their medical expenses or other expenses. Weightage in qualifying services, etc., has been withdrawn. Earlier, when suppose someone, because even after 20 years of service, the full pension was payable. So accordingly, the weightage of qualifying service, that proportional calculation has been withdrawn. General issues in pension matters leads to non-settlement. Say, in suppose GSI has not been settled. In many cases, in ICR system, a person gets transferred from one institute to other. In such cases, if his GSLI's account is not transferred from one institute to other, then it becomes a problem for the retiring person to get its claim under the GSLIS. Many of the people doesn't know about the claim of DA which he can get or which he or she can get at the time of retirement. withheld amount of gratuity not paid despite NOC, even after getting the no objection certificate and no demand certificate from the different sections of the council or say institute, the gratuity, withheld gratuity is not released. Leave encashment is not paid even after 1 year. Non-payment of CVP by the bank, or say bank is paying full pension and they are not deducting the CVP committed part from the pension. These are the certain issues on which the grievances are generally raised by the pensioner and needs to be settled. Certain other issues are there, like delay in authorization of pension or family pension after the death of the pensioner. We all need to be a bit uh, mm, send the grievance and need to be set. Provide some comfort to the family pensioner who is already suffering from some issues after the death of the pensioner of the after the death of the employee. So the family pension should be authorized as early as possible. In certain cases, when disciplinary proceeding is underway or non-completion of formalities or non-submission of documents has taken place on behalf of the employee or the family pensioner or the pensioner, the pension gets delayed. In case of lost PPO also, or the shifting of PAUs, because in ICR, we might have heard about the shifting of PAU from one PAU. The cases were shifted to some other PAUs that has led to the quite certain amount of harassment or say inconvenience to the pensioner. Issues to be taken note by the pension authorizing unit. These are the issues for the pension authorizing unit. They need to reconcile the payment with the actual entitlement. Generally, whatever scroll bank issues, we take it as a payment. However, and we don't try to get it checked with the actual entitlement, but the rule says that uh, whatever is actually due should only be paid by the bank, and any say excess payment should be recovered. In certain cases, when CVP has been restored, then also bank uh, deduct the CVP, or otherwise also bank when the CVP has to be deducted from the pension, but bank pays the full pension. All such cases needs to be checked in from the scroll. Pension of payment of FMA, which is being revised time to time. Okay. FMA is being paid to the pensioner when he has opted for the dispensing facility. Non-authorized pensioner being paid pension out of ICR funds. These are certain issues which and pension authorizing unit needs to check. So while preparing by this PPT, I have took the help of following documents: CC's pension roll, then retirement benefits, which is available on the DOPT site, and certain other books which are have been referred here. So that was all from my side. In case of any queries, because I'm right now a bit occupied with some other issues also, so I'm winding up my presentation. In case if you have any doubt, you may please raise it.
Sir, please go through the chat, sir. Chat.
Chat, okay.
Yeah. Should I tell? Should the bank account be joint account always? One question.
Yes, it should be joint account.
Next, sir.
It should be joint account. Then second one is, sir, in case of an unmarried employee, if he don't have any family, can he nominate any other person other than family member for service benefit? I have already shared the details of family details in respect of different cases of employees. You please go through that slide. I will share this slide to all of you. And gratuity is 25 lakh. Very well taken. I have already accepted that thing that it is not 20 lakh, it is 25 lakh. What is the status of unified pension system? Right now, we are awaiting any confirmation from you from Ministry of in respect of UPS. As and when this they will notify about it, we will implement it in the ICR after due approval from the appropriate authority. So as of now, it is wait and watch only.
Sir, I doubt, sir. Sir,
Please.
ask please.
sir.
वीडियो ऑन कीजिए, पूछिए.
Yes, sir. Sir, in case of new pension scheme persons, assume that he demised while.
So your voice is not audible. It's getting.
थोड़ा क्लियरली बोलिए, थोड़ा ऑडिबल नहीं हो रहा है, थोड़ा क्लियरली बोलिए, धीरे-धीरे बोलिए.
सर, अगर न्यू पेंशन स्कीम के एम्प्लॉय जो भी है, अगर वो लोग सर्विस के दरमियान गुजर जाते हैं, तो
So in case of new pension employees who dies in harness during the course of service, then also, and if they have already applied for Rule 10 of the CCS new pension rules, in that case the family dependent of that employee will be covered under the old pension scheme, and whatever say corpus is accumulated under the NPS fund of that particular employee, the employee part in that part, the employer's part and employee part will be segregated, and the employee part will be payable to the dependent of the pensioner, the employee, and the employer's part will be credited to the ICR's account.
Then what about pension, sir?
Pardon?
Pension. Family pension will be same as OPS.
Family pension will be payable. Family pension will be payable to the dependent of the government servant as per his combination papers, what he has submitted at the time of joining, and his NPS, in respect of his NPS corpus, the employer's contribution